If you move with your child without following Florida's relocation law, a judge can order your child brought back immediately, and you could lose credibility in your custody case overnight. Relocation cases, what many people casually call move-away cases, are some of the highest stakes battles in Florida family court. Whether your co-parent wants to leave the state or just move a few counties away, this issue can permanently change your relationship with your child. Today, I'm going to explain exactly how Florida courts decide relocation cases, what the statute requires, and the mistakes that get parents crushed in court. What counts as relocation in Florida? Under Florida Statute 61.13001, a relocation means a change in the location of the parent's principal residence, more than 50 miles from the residence at the time of the last court order or filing, for at least 60 consecutive days. This is not just about moving across the country. A move from Miami to West Palm Beach or Orlando to Tampa can absolutely trigger the relocation statute. There are only two lawful ways a relocation happens in Florida. 1. Written agreement. Both parents sign a written agreement consenting to the relocation, including a revised time-sharing schedule, transportation arrangements. This agreement must comply with the statute and be approved by the court. 2. Contested petition to relocate. If there is no agreement, the parent who wants to move must file a petition to relocate and prove the move is in the child's best interest. Critical warning: do not just move. This is where parents destroy their cases. You cannot move first and ask permission later. If you relocate without an agreement or court order, you can be held in contempt. The judge can order the immediate return of the child. Florida appellate courts have repeatedly upheld this, including cases like Blatt versus Blatt. Even worse, your petition must be legally sufficient. Under cases like Vanderhoof versus Armstrong and Lane versus Fuller, your relocation petition must include the specific address of the new residence, a detailed post-relocation time-sharing schedule, clear transportation arrangements and costs, a written job offer if employment is the reason for the move. If you leave these out, the court can dismiss your petition before you ever reach a hearing. The Florida relocation factors. Relocation cases are governed by Florida Statute Section 61.13001(7). There is no presumption that relocation is allowed. The parent seeking relocation has the burden of proof to show, by a preponderance of the evidence, that the move is in the child's best interest. If that burden is met, it then shifts to the other parent to show why relocation should be denied. Judges must analyze specific statutory factors, including parent-child relationships, the nature and quality of the child's relationship with each parent, and whether relocation will preserve the relationship with the non-relocating parent. Age and developmental needs. The child's age, maturity, and specific emotional and developmental needs. Feasibility of time-sharing. Can the relationship realistically be maintained? Can the parents afford travel? Is the transportation plan workable? Child's preference. If the child is of sufficient age and maturity, the court may consider their wishes. Quality of life. Whether the relocation will actually improve the quality of life for the child and the relocating parent, not just convenience. Reasons for the move. Is this a legitimate relocation or an attempt to interfere with the other parent's relationship? Economic circumstances. Whether the move meaningfully improves the family's financial situation. History of violence or substance abuse. Any domestic violence, abuse, or substance issues are taken very seriously. How judges apply these factors. Judges don't tally these factors like a scorecard. They conduct a fact-specific, credibility-driven analysis. For example, in Lane versus Fuller, a parent tried to justify relocation based on a job offer, but the job was remote. The appellate court rejected that as a valid reason to move. In Marini versus Kellett, the court found it unreasonable to require a young child to endure dozens of flights each year when the parents couldn't afford it. Logistics matter, motives matter, credibility matters. Temporary relocation. Sometimes a parent claims they must move immediately. Florida does allow temporary relocation, but it is difficult to obtain. The court must find a substantial likelihood that the relocation will ultimately be approved at final trial. This almost always requires an evidentiary hearing. Temporary relocation is not automatic, and it is rarely granted without strong evidence. Relocation cases can permanently reshape your role in your child's life. If you want to move, you carry the burden of proof. If you're the parent staying behind, you must be ready to show how the move harms your relationship with your child. One final piece of advice: do not pack. Do not sign a lease. Do not move your child until you have a court order or a properly drafted written agreement. If relocation is on the table in your case, get guidance before you make a mistake you can't undo.